Hello, everyone, and welcome to this Authors Guild educational panel on the Copyright Claims Board, what authors and agents should know. Thank you to our panelists for being here. Thanks to everyone who submitted a question in advance. You can use the Q&A box below to submit a question at any time, and we have closed captions available under the transcript button. And I'll go ahead and turn it over now to Authors Guild CEO, Mary Rasenberger.
Thank you, Johnny. Welcome, everyone. Good afternoon or good morning, depending on where you're zooming in from. So as Johnny said, our panel today is the Copyright Claims Board, what authors and agents should know. We are co-hosting this webinar with the Association of American Literary Agents, or AALA, on how, for authors and agents specifically, on how to use the Copyright Claims Board, or CCB, you'll hear us call it. And I'll also refer to the Association of American Literary Agents as AALA. So first I want to introduce our panelists. We are delighted to have such a distinguished group of panelists for this webinar. First, we've got Pamela Malpass, who has been a literary agent for over 25 years, representing award-winning writers of fiction and nonfiction. And she is a member of the Association of American Literary Agents and has been since 2010. She currently serves as AALA's chair of the Copyright Committee, which fosters education and discussion on topics related to copyright. And I want to mention that Pamela approached us about doing the webinar, so thank you, Pamela. Next, we have Whitney Levin Dusky, and I don't know if I said that right, Whitney. Okay. She is Supervisory Attorney Advisor of the Copyright Claims Board at the U.S. Copyright Office and has been at the Copyright Office since 2015 and other positions. Terica Carrington is Vice President, Legal Policy and Copyright Counsel at the Copyright Alliance. And she advocates before Congress, the U.S. Copyright Office, and other federal agencies on a number of legal and policy issues, including the CASE Act, which was the Copyright Alternative and Small Claims Enforcement Act, which created the CCB. Terica is also an adjunct professor at George Mason University School of Law. So I'm just going to give you a few kind of highlights of the Authors Guild interests in the CCB before I turn it over to the panelists. As I think you all know, the CCB is a new tribunal in the Copyright Office that just opened its doors on June 16th for small copyright claims, and I'll let the panelists tell you more about the types of claims that can be brought. But I want to just mention why we lobbied for this for so many years. The Authors Guild first introduced the idea of a small claims court back in 2006. My predecessor, Paul Aiken, testified about the need for a small copyright claims court in 2006. The Copyright Office then commenced a study at the request of a number of creator groups, including the Authors Guild, and published a report in 2013. Shortly after that, we started working on legislation. I think shortly after I came to the Authors Guild in 2014, it might have been 2015, we started working closely with Congressman Hakeem Jeffries' office on draft legislation. And then we worked on all the subsequent iterations into the two subsequent congressional sessions. So over 6 years, we worked on the legislation. We met with well over 100 different offices. Hundreds of members wrote letters and made phone calls to their representatives to support the CASE Act. And so I want to just thank all our members who helped, and a special shout out to the Oregon members. As you may remember, Senator Wyden put a hold on the bill for about 1.5 years, wouldn't lift it, and our Oregon members really came out to support the bill, attending town halls that Wyden had in Oregon and meetings even at his offices. So thank you very much. The CASE Act was finally enacted as part of the year-end Consolidation Appropriations Act of 2021. And the reason we spend so much time on it is that few writers can afford to sue to enforce their rights. Copyright is the basis of the writing profession. It's what allows you to earn money from writing. It's what allows publishers to earn money. But it's been an empty right for writers and other creators for many years because you cannot enforce it in many cases. The average cost of a lawsuit is approximately $400,000, higher than the damages in most cases. And it means that you can't afford to enforce your rights. And I saw that in private practice before I came to the Authors Guild and since coming to the Authors Guild. And it is just incredibly upsetting when, somebody's rights have been trod upon, clearly infringed, and you can write a cease and desist letter. But there comes a point where you either have to decide to bring a litigation or not, if the other party won't cooperate, and it's generally completely unaffordable. So, it left writers and other creators with an empty right. And, I see it as an access to justice issue, and that's how we lobbied for it. In the end, we did not get a perfect bill, and we maybe get into some of that, but we did succeed in getting it up and running. And I think the next year we'll see how well it's functioning, and if there need to be adjustments. The Authors Guild did fight for higher caps. The cap per claim per work infringed now is 15,000. We wanted higher caps because, of course, a single book for an author can be 3 years of work, and 15,000 may not come close to compensating for that. But it is a small claims court, and we did what we could to get it higher, but that's as high as we could. And a lot of other creators, like photographers, they might take 1,000 pictures a day, so they could. The smaller caps were fine with them. The only other thing I want to mention is the CCB does allow respondents to opt out, and that was considered essential to pass constitutional muster, and I'll let our panelists talk more about that. But we do believe that people will see the virtues of being in the CCB, and that the existence of the CCB will lead to more settlements. Last, I want to mention that if you have a claim that you think is suitable for the CCB, file a request for legal assistance with the Authors Guild. If you're a member, if you're not a member, you can join $135 a year. We will first help you evaluate whether you have an appropriate claim for the CCB, and then we will help walk you through the process. We won't be actively serving as your counsel in the CCB, but we will be behind the scenes walking you through the process. And so now I would just like to turn it over to our panelists. I'm going to start with Terica, who's going to talk about the purpose of the CCB and how the process will work in practice. Thanks, Terica.
Thanks, Mary. And hello, everyone. Again, my name is Terica Carrington. I'm VP Legal Policy at the Copyright Alliance. Mary just shared a lot about why the Authors Guild advocated for the CASE Act and why the CCB is important. And I just, echo many of the same points that she made. This was something that the Copyright Alliance also advocated strongly for over the last several years. And we're really excited to have the CCB up and running and to have a new tribunal where creators can have their rights enforced and have an opportunity to have their cases heard. So I am going to go into some key features of the CCB and some points to kind of highlight what exactly the purpose is and how it works. So again, Mary talked a lot about, the need behind the CCB and why the CASE Act was drafted. It's federal court was the only option for creators that had rights that they wanted to enforce their copyrights. And so because it's so expensive, there was a gap essentially that needed to be filled. And the CCB is going to be a great step towards filling that gap. And so some of the ways that it does that is the CASE Act created the CCB to be a voluntary, streamlined, and affordable alternative to federal court for certain small claims. And I'll get into that in a little bit. But just to kind of break down what exactly is entailed in what I just described. So first of all, as I mentioned, the process is voluntary. And that means that it's optional both for claimants and respondents. So the claimant who has a suitable copyright claim can still choose to go to federal court if they can afford to go to federal court and if they want to. So again, this is an option as an alternative to federal court. And then on the other side, respondents also have the ability to choose whether or not they want to participate in the proceeding. If they do, that's great. And if they don't, they don't have to have any specific reasons for not doing so. There's a pretty straightforward opt-out process, as Mary touched on as well. And in addition, the process is streamlined. So the process is designed to be simplified and streamlined as compared to federal court. And one of the important reasons why this is the case is that this allows parties to be able to represent themselves. So kind of going back to how expensive federal court is, usually a big part of the expense associated with that can be hiring an attorney. And so by making this process streamlined and simplified enough that individual creators can represent themselves, that helps take away some of that significant cost associated with the need to hire an attorney for federal court. And the next feature I'm going to highlight is that, again, it's more affordable compared to federal litigation. So since parties can represent themselves, that's one of the big major cost savings, is not having to hire an attorney. And they're also able to get pro bono representation from law students, which is a unique feature of the CCB. It's sort of a happy medium for parties that don't feel entirely comfortable representing themselves, but don't want to pay the cost associated with hiring an attorney. They can get pro bono assistance from law students. In some cases, they might be in legal clinics or in other organizations associated with a law school, but that basically gives these creators the opportunity to have some sort of legal expertise without the cost associated with it. And then I also mentioned that these are for certain small claims. And so what I mean by small claims is that damages are significantly less in the CCB as compared to federal court. So in federal court, damages for copyright infringement can be up to $150,000 per work infringed. And in contrast, the statutory damages at the CCB are limited to $15,000 per work infringed. And then there's also an overall maximum damages that can be awarded in any single case, and that's $30,000 at the CCB. And comparing that to federal court, where there is no overall, maximum limit of the number of damages that someone can be awarded. And it's limited to certain kinds of claims, not all. And those claims are, the first one is infringement. The second one is declaration of non-infringement. And the third one is 512F misrepresentation claims. And so I will get into kind of details about what each of those means in a little bit, but I do just want to highlight right now that those are the only three kinds of claims that can be brought. So for example, ownership disputes are not suitable to be heard before the CCB, and also, other kinds of intellectual property disputes, trademark and things like that, wouldn't be appropriate to bring at the CCB either. And then also I just wanted to highlight another, benefit and great feature of the CCB, which is that there's no travel required. So in federal court, traditionally someone has to appear and to represent the party at the actual location where the court is located. But the CCB, even though it's housed within the US Copyright Office, which is located in Washington, DC, there's no need for anyone to actually travel to DC to be a part of their case. Everything is done virtually and online. The different documents that are going to be exchanged can be done online, and any hearings or conferences that would be held virtually. And what I think is also interesting about that is that was actually a feature of the CASE Act well before the pandemic. Like, that wasn't something that kind of came about because everything went virtual. That was actually in the original first version of the CASE Act that was introduced in 2016, also had everything pretty much happening electronically and virtually as well. So next, I'm going to talk about who can bring claims before the CCB, and really, who benefits from the existence of the CCB. And so I know I've been talking mostly from the vantage point of creators throughout, everything that I've said up until right now. That's because, I work at the Copyright Alliance, and we advocate on behalf of creators, copyright owners. But the CCB is actually of benefit both to creators and users of copyrighted works. And so I want to also highlight that and make it clear that, although creators can bring infringement claims. There are also certain kinds of claims that users of copyrighted works can bring as well. And I'll get into a little bit more detail on that in a little bit. But so of course, it's going to be of benefit to individual creators who haven't been able to afford to litigate their claims historically in federal court. But it's also of benefit for users of copyrighted works who also now can have an affordable forum to have those claims heard as well. And then in addition, there's that limited liability for users of works, potentially, let's say if an infringement claim is brought against someone who's using a copyrighted work, there's that limited liability at the CCB as compared to federal court. And then I think we also got a question ahead of time on this, so I did just want to touch on this as well. Foreign residents can file claims before the CCB. So what's interesting about that, and one thing that I want to highlight and just make note of, is that although foreign residents can file claims against US residents can't bring claims against foreign residents, with one slight caveat. If a foreign resident does bring a claim against you as a US resident, you can file a counterclaim, but you can't be the claimant who brings a claim against a foreign resident. Okay, and now I'm going to go into a little bit more detail about those specific claims that I was highlighting, the 3 types of claims that can be brought before the CCB. So again, the first one is infringement claims. And these are claims that, you know, a copyright owner would be bringing against someone that they are alleging to have infringed one or more of their exclusive works. And this is not just limited to online infringement. This is, you know, infringement of all kinds can be brought before the CCB. The second kind of claim I want to highlight is declarations of non-infringement. So if a copyright owner has accused a user of a copyrighted work of some sort of infringement or has threatened to take action against them, that user can actually bring a declaration of non-infringement case to the CCB and request that the CCB issue a declaration basically stating that whatever the activity is does not infringe the copyright owner's exclusive rights. So as I mentioned before, this is, you know, one of the examples of how users of copyrighted works also benefit from the existence of the CCB as well. And then finally, I'm going to touch on the third kind of claim that can be brought, which are 512F misrepresentation claims. And so just to give a little bit of background, because I know that kind of probably sounds like some sort of weird code or something, but that refers to section 512F of the DMCA. So as many of you are probably familiar with, one part of section 512 creates the notice and takedown system where creators can, you know, copyright owners can send a takedown notice to a platform and have the platform take down infringing content. So as a part of that notice and takedown system, you know, the copyright owner can send a notice, but the user of the work could also send a counter notice if they believe that they have basically been wrongfully accused of having infringed someone's work. They can send a counter notice and have the platform put the content back up. So what this 512F misrepresentation claim gets at is if a copyright owner sends a takedown notice and the user feels that the copyright owner misrepresented that the activity is infringing, they can bring a 512F misrepresentation claim, essentially saying that, accusing the copyright owner of making a misrepresentation in the takedown notice that they sent, and have the CCB decide that case. And then on the flip side, if a user of a copyrighted work were to have sent a counter notice back to the platform, and the copyright owner feels that there was some sort of misrepresentation in that counter notice, they can also bring a 512F misrepresentation claim before the CCB. So those are, again, the 3 kinds of claims that can be brought. There are no other permissible claims, even though there are other types of copyright claims. What the CCB is allowed to hear are limited to those 3 claims. And so I do want to circle back quickly to infringement claims to highlight an important thing to keep in mind for anyone who is interested in potentially bringing an infringement claim, is that before you bring that claim, the work at issue in the infringement dispute has to have either already been registered by the Copyright Office, or the work must be the subject of a pending registration application. So the office must have already issued a registration certificate, or the application has at least been submitted to the Copyright Office. And so although you can file that claim, the CCB actually cannot issue their final opinion or their final decision on the case until the work is actually registered. So if you filed your case based on a pending registration application, that's totally fine, that the case can move forward, but they can't actually issue their decision. So the case can't fully wrap up until after the Copyright Office has finished the examination process and issued the registration certificate. So in some cases, the copyright owner will have already registered their work well before ever bringing their claim. But for copyright owners who have not yet submitted a registration application for the work, they can submit that application to the Copyright Office immediately before filing their claim with the CCB and just move forward straight from there. And I also wanted to highlight, going along these same lines, the expedited registration process and the option to do that through the CCB. So right now, the average processing time for a registration application with the Copyright Office is about 3 to 4 months. And if there's any more updated information on that, I'm sure Whitney can correct me. But I think it's about 3 to 4 months. And so, if you're intending on bringing an infringement claim and you have either a pending application or you're getting ready to file your registration application with the Copyright Office, that's something to kind of keep in mind, is how long that current processing time is and whether or not you're comfortable with that time, or whether or not you might want to expedite that and get your registration application completed faster. And if you do choose to expedite, there is a specific process that relates to cases that are being brought before the CCB, infringement claims that are being brought before the CCB. The copyright owner can request expedited registration through the eCCB system, which is the electronic website that facilitates everything having to do with CCB cases, and pay an accompanying fee, which is right now $50. But there are two important things to keep in mind that I want to highlight about this expedited registration process. One is that this request can only be made once the case becomes, quote, active. And what it means for a case to become active is if you are bringing a claim and let's say you're the claimant, you're bringing a claim against a respondent, again, it's optional and voluntary for both the claimant and the respondent. So the respondent can choose to opt out and has 60 days to decide whether or not they want to do that. But once that 60 days passes and the respondent has not opted out, the case becomes active. So if you want to make a request for a registration application to be expedited, you have to wait until the case becomes active, until those 60 days pass and the respondent hasn't opted out. And then you can go ahead and make that request. And the second thing I wanted to highlight is that the request must be made through the eCCB system and not through the regular Copyright Office registration system. And in general, the Copyright Office will aim to complete that expedited review within 10 business days. So again, we want to keep in mind the current processing time of whenever it is that you're seeking to file your claim. Right now, it's 3 to 4 months. So comparing that to 10 business days, if you wanted to get it done really quickly, you could go that option. And the next thing I'm going to touch on is what should you do if you get served. So copyright owners can also be respondents in cases as well. And so if you get served with a notice that there's a claim against you at the CCB, it's important to review all of the materials that come as a part of the service of process. They're going to explain the claim against you, as well as the implications of deciding to participate in the proceeding or deciding to opt out of the proceeding. If you want to participate, it's very simple. You pretty much do nothing. You just wait until the CCB issues an order instructing the parties on how to register for the eCCB system, and they'll follow up with additional instructions from there. If you don't want to participate, you'll follow the instructions that are provided with the service of process as to how to opt out. And again, you have 60 days to opt out if that's your choice. So what kinds of assistance is available for claimants and respondents? So as I mentioned, lawyers are optional, but they are still allowed. So if someone has an attorney that they're working with or want to hire or want to work with, that's still definitely allowed for the CCB. But in addition, there are also lawyers who provide pro bono or, quote, low bono assistance. You can contact local VLAs, which stands for Volunteer Lawyers for the Arts. There are various organizations throughout the country that do offer services and partner with attorneys who will provide low bono or pro bono assistance for copyright cases. And so on the Copyright Alliance website, which is copyrightalliance.org, on our menu, we have a drop-down titled Resources, and underneath that, there is this choice of Creator Assistance Directory. And we actually have a directory of various volunteer lawyers for the arts organizations all across the country, as well as different legal clinics, which brings me to my next kind of assistance that is potentially available for claimants and respondents. And those are, again, law students. As I mentioned earlier, there is also the option to have law students represent parties before the CCB. And so we also have in that Creator Assistance Directory, there's a list of different legal clinics at law schools that also are available for pro bono assistance as well. And one thing I also want to highlight, which is that the CCB attorneys themselves, which we have Whitney with us, who's one of the supervisory attorneys with the CCB, they provide assistance helping to educate parties on how the system works. They don't provide legal advice. And so even though they're called CCB attorneys, they're not your attorney, but they can help you understand the process and answer different questions that you have. And I'm sure Whitney's going to touch on that in some more detail. And then the last thing I wanted to highlight is that the Copyright Alliance also has various resources for educating creators on the process as well. If you are a Copyright Alliance member, you probably have already seen some of these things, but on our website, we have various videos. We're working on updating our CCB guide, which walks through the process from start to finish. We had a previous version of this guide, which some people may have seen, which came out before the CCB actually launched back when after the CASE Act passed. And so we kind of gave a high level overview of what to expect the process to look like. But now that the CCB has actually launched and the Copyright Office has issued their regulations, we've been able to fill in the gaps a lot more. So we'll be having an updated version of that soon, as well as FAQs, blogs, and other things like that, and more things to come as well. And then finally, before I turn things over to Whitney, I'm just going to quickly touch on the appeals process. So there are, and I should actually probably call that the review process. I think that's probably a little bit more of an accurate description. So there are two kinds of review/appeal possibilities under the CASE Act for the CCB and different decisions that come out of the CCB. The first one is an internal review process. So if, let's say you are a party to a case and you're not happy with the decision, perhaps it's a decision against you and you're not happy with it, you can request reconsideration by the CCB. And so that is pretty much what it sounds like. You're requesting that the CCB basically look at the case again. Perhaps you're saying that there was some sort of error or mistake in the decision and you're asking them to reconsider it. They can either choose to reconsider it or they can deny that request. And if they deny that request, you actually have now a second level of review, which is you can request that the register review the CCB's denial of your request for reconsideration. So I know that was kind of like a mouthful, but basically you can ask the register to kind of look at that decision and decide whether or not it was appropriate or decide if the CCB abused their discretion in some way in denying your request. So those are the levels of internal review that can happen. And then additionally, there's very limited opportunities for appeals to federal court. And so it works a lot like the appeals possibilities for arbitration. It was actually the legislation itself was kind of mirrored after similar legislation related to arbitrations and what's available for district court review there. But basically it's limited to a couple different kinds of issues. So the first one is if the determination was the result of some sort of fraud or corruption or some sort of misconduct essentially by the board, you can ask the district court to review. And then the other one that I'll highlight, there are actually a couple different reasons, but I'm just going to highlight a couple of them here. The other one is that if you have a default judgment decided against you, so let's say you, for whatever reason, just missed all of the information that the CCB sent you and that the other party sent you, and there was a default judgment issued against you, which basically means that the other party won, they were able to prove their claims and you weren't there to defend yourself or to make your argument, and a default judgment was issued against you, you can actually appeal to appealed to the district court, arguing that there was some sort of excusable neglect. So maybe there was some, you were in the hospital or something that basically explains why it is that you didn't participate in the case, and you can seek to have the district court change that decision or vacate that decision entirely. So those are kind of the high level things that I just wanted to highlight about the CCB. And I'm sure we have some questions coming in. I'm happy to take some questions at the end.
Terica, thank you so much. Before we move on to Whitney, I just want to mention a couple of things. There are a lot of questions coming in, and they're great questions. So we will get to them at the end. And to the extent we can't get through all of them, we'll try to respond to people offline. There are a lot of questions about copyright law. We are not going to address those today, but we will have a separate webinar on basic copyright law as compared to trademark, unfair competition. I will do it, and I'll take yours. There are a lot of specific questions about your individual situation. I can address those then too, but we're not going to try to take those on today. We have so much to talk about with just the CCB. Also, somebody asked if you could all slow down in your talking, because there are subtitles for the hearing disabled, and apparently the subtitles weren't keeping up. So just bear that in mind. So let me turn it over now to Whitney, who's going to talk about the CCB process from the perspective of the CCB.
Absolutely. Hi, thank you, Mary. Thank you very much for having me today. Thank you also, Pamela, for organizing, striking up the conversation for this event. I just want to give you today just a brief overview about who we are, how we can help you, and what it's going to look like when you work with us, or you bring a claim, or you find yourself to be a respondent. So if, Johnny, throw up the team. So I do have a slide showing who we are. So we are made of 3 copyright claims officers, and we'll see some pictures of them in a hot second. Cool. So this is us. This is the Copyright Claims Board. When you hear the phrase CCB, this is who we're talking about. So we have 3 copyright claims officers. We have David Carson, Brad Newberg, and Monica McCabe. They will reach final determinations as a group. If we do have a smaller claims proceeding, which is a process for an even more streamlined dispute resolution, and that's working with one officer directly. So when there's a claim brought, the parties will be working with a CCO during the active phase, very much during the active phase, working through conferences, working through discovery issues, conducting hearings, issuing final determinations. So these are our longtime copyright experts. We did informal math, and we think there's about a century of copyright expertise between the 3 of them. So we are looking at decision makers with a wealth and depth of copyright experience. Then we have, as Terica mentioned, the copyright claims attorneys. That's myself, Dan Booth, Maya Burchett. We are going to be talking with participants. We'll talk with participants sort of throughout the proceeding. We do a lot of work. We will be doing a lot of work with claimants through the compliance review process, which I'll talk about in a second. And then we also are here to answer general inquiries and talk to anybody who wants to hear about the CCB. So again, thanks for having me on. Then we have our paralegal, Laura, and our program specialist, Natalie. They are going to be pretty much running the show. They maintain the docket. They answer general inquiries. They will be sort of the people to go to with the nuts and bolts questions of how we operate. So just to put some faces to sort of the overall organization, the acronym of CCB, this is us. Now, let me walk you through the process. Next slide. We kind of think about the CCB proceeding happening in 2 phases, the initial phase and the active phase. The initial phase is really the time where everybody decides to get involved with the CCB. So the claimant decides to get involved with the CCB by filing a claim. That claim goes through compliance review. Compliance review is a specialized procedure where the copyright claims attorneys review the claim to make sure that the claim meets the legal and regulatory requirements for a claim before the CCB. And so what that really means is that we're looking for the claimant to tell their story, you know, the who, the what, the where, the when, the why of their cause of action. We are looking for this for two reasons. One, we need to make sure that this is the type of claim that the CCB can hear. Two, we need to make sure that we have all of the ownership and registration information together as appropriate, sort of as Terica described with the registration requirement. Three, we want to make sure that there's remedies that we can give you. You know, because we have that $30,000 cap, because we only have voluntary injunctions, we want to make sure that when a claimant comes to us, that we can provide the relief that is sought. And then four, we want to make sure that the respondent can decide, because that's super important. And I think I've seen some things in the chat that's like, well, if a respondent can just opt out, what's the point? And yeah, what's the point? The system works best when we have claimants and respondents that want to be at the table. So the compliance review process helps the respondent, helps the claimant and the respondent by making sure that we have a story, that we have a dispute, that the claimant and the respondent can resolve. And so after we find a claim compliant, we'll issue it to service. The claimant has 90 days to serve. After service, the respondent has 60 days to opt out. And this is that period of deciding whether or not to participate, as Terica described. When we have a respondent that doesn't opt out, we move to that active phase. Next slide. And so this is sort of that dispute resolution phase. So we have two people that are participating here that say, yes, I want to resolve this dispute. I recognize that this is an advantageous venue for me. So respondents might want to, participate because of our streamlined processes, because there's a consideration of federal litigation, because this resolves sort of legal ambiguities that are parts of a business consideration. So once we have a respondent that is opting in, we have this active phase. We will have a conference that gets the parties together to sort of set forth how things are going to go. We want to make sure, since this is a new procedure for everybody, we want to make sure that participants understand what's going to happen and how things are going to go. We do have a list of standard discovery requests, questions for documents, requests for information. And this is really just the phase where parties go back and forth. They exchange the information that they have that relates to the claim. This is a standardized process for us. And that's one of the streamlined features over federal litigation. After that, we have written testimony. So that's making the case. That's the claimants and respondents making their arguments. And then we will have a virtual hearing that's optional, Zoom, as we mentioned, before reaching a final determination. So throughout this process, where is the CCB? How are we providing guidance? I like Terica, how she mentioned that we are attorneys, but we're not your attorney. We are government attorneys, which means that we have all of our sort of advising and legal duty is to the government rather to any individual. But that doesn't mean we can't help. We can help a lot. We can explain processes and procedures. We can help you, point you in the direction of, how do I file a claim? How do I understand what information I need to provide? Excuse me, what do you mean by damages? What statutory damages? Never heard that before. We can explain legal terms that you may encounter for the first time in a CCB proceeding. We can explain the issues that the steps that you'll have to take during an active phase. We are here to provide all the information that we possibly can to help participants understand how to resolve a dispute before the CCB. In terms of the timeline, we don't really have an overall timeline yet because we just started accepting claims on June 16th. So we don't know what the full life cycle is like. We have started issuing some decisions related to compliance on the first set of claims that we've received. So we know that we can, clear things up, start moving things forward within a couple weeks. And we'll see as the volume changes, as we move into active phases, how long things take. And just to emphasize, with this information and with these proceedings, we intend that you don't need a lawyer. This should be a process that anyone can navigate on their own, but we do recognize that having a lawyer can be advantageous. And Terica went through some of the pro bono resources that are available. We will have those, many of those resources listed on our website at ccb.gov. And then if you ever have a question about anything process-based, anything about the CCB, how we operate, what our expectations are, you can always email, I'll put it in the chat, asktheboard@ccb.gov. That's our main line. So I'm happy to answer questions. I look forward to talking a little bit more with everybody, and I think I will pass it on to Pamela.
Whitney, thank you very much. Those were both excellent summaries. There's so much to know, and we're really fortunate to have both of you. I should mention that Terica oversaw the Copyright Alliance's comments on all the regulations, and took feedback from all of the Copyright Alliance members, which was a lot of work. So you both know the process inside out. Just great. I did just want to also mention that as I said, the Authors Guild will help members through the process. Somebody said, what about if you're a non-member? We provide free legal services to members, it's a real deal. If I can toot our own horn, we have a staff of attorneys that provides free legal services. So no, we only provide them to members. You have to pay, you can join them. We have a lot of members who join just, to get legal services. And as I said, it's only $135. I do want to move on to Pamela now, and then we will we'll go over some of the questions from the audience. And you can continue to put questions in the Q&A. Thanks, Pamela.
Sure. Thank you. I'm going to try to keep my comments brief because I'm not the expert here. The experts have already spoken, and I just want to thank everyone for being available to this venue to actually help people understand a little bit about what this new tool is. And I'll just say a few words about why I'm here. I'm here representing the agent community as a member of the Association of American Literary Agents and chair of its copyright committee, which is a committee that exists to stay on top of critical developments in and threats to copyright. And I think while we've found that the last several years have brought new challenges of many kinds, there have also been positive developments, and the ongoing modernization of the Copyright Office systems and the launch of the CCB are definitely among those positive developments. I'd say, the agent perspective is that all agents have multiple clients. Most agents have years or decades of experience. And as a result, agents tend to have a very broad range of situational experience of more than a single author can have, just because we're dealing with issues that arise for all our clients, for authors and illustrators, film and TV, all kinds of things. So agents are often a first resource for authors on many subjects, and that can include copyright. It can help our clients understand how copyright works. I think most agents are aware that the CCB is a potentially significant development for authors. All of us in the agent community have dealt with innumerable copyright situations, questions about fair use, unauthorized posting of our clients' work online, takedown notices, more takedown notices, and authors feeling kind of powerless against the kinds of infringements that have exploded with the advent of internet platforms and the easy movement of digital formats. I think critical thing is that the CCB gives individual writers power. It doesn't matter if the author is a bestseller or the author of a little gem of a masterpiece published by a small press. Any of those authors now has the same potential power as a big corporation. A big corporation can afford to take something to federal court, and most individual authors can't do that. They don't have the time or the resources. And I think the CCB puts that copyright protection power within the grasp of every writer who's willing to try it. From my point of view, and I would say the experts can correct me on anything that I'm misstating, but the CCB is, from my view, adding something. It's without taking anything away. People can choose to pursue something through this venue, or they can choose to pursue it through federal court. Nothing has been taken away from anyone. I'm just looking to see if there's anything more that's really relevant I can say. I think what agents can do to help their clients is, I think we can all bear in mind that an agent's reason for being is to help their author get compensated for their work. And the reason for that compensation comes about because of copyright. So we definitely understand the value of copyright, and we can help our authors understand how copyright works and why they should be passionate about it. I would say no author should be taking copyright for granted. It's not a thing that we should think of as acquired passively, like a suntan. I mean, it's something you need to think about. Stay on top of your copyright registrations. Agents can help the clients do that, help monitor whether the works that are under contract have been registered by the publisher within that critical 90-day period from publication. That is quite important. We can also help our clients navigate what their publishing contract might say about infringement claims and settlements and so on. And I would also say that any agent who represents literary estates can tell you that even if you're not really clear on the value of copyright, your heirs probably will be. And what you pass on to your children or other heirs includes your copyrights. And so even if you're not sure you value it, your heirs might value it. And so you can think about that. And I'm going to pause now because I think the important thing is to answer questions and to be corrected on anything that I might have been misstating.
Thank you, Pamela, and thanks again for co-hosting this webinar today. So we'll open it up for questions. Again, we've gotten so many great copyright questions, which I would love to cover in a separate webinar on copyright, including questions about the rights of descendants. So I think the way, because we've got about 12 minutes left, so and we have so many good questions, and I think they can be answered pretty quickly. So I will just, ask one of you to answer them and try to keep your answers short, because there are a lot of really good practical questions. So the first one I'm going to ask about, which we, before the webinar today in the pre-submitted questions and today I'm seeing, is what about fair use? Does the CCB take fair use into consideration? This is if an author is a respondent in a case, can they plead fair use, and how does that come into the case? Whitney, want to take that, or Terica?
Sure, I can take that. Yeah, so fair use is going to come up in two areas of CCB proceedings. The first is that they can come up in claims themselves. So we can hear a claim for a declaration of non-infringement. So this is for a user of a copyright protected work who believes that they have a fair use. Since fair use is usually a case-by-case determination that can only be permanently settled by a judge, a lot of fair use issues or sort of conflicts can go unresolved or feel ambiguous or outstanding. So this is a good way for people who find themselves in areas where they might want to consider fair use or might have a fair use and would like a solid determination. They can come to the CCB and receive a determination from 3 copyright experts. So that's the first time that fair use will come up. The second time is in that more traditional respondent context. So a claim can be brought for infringement after the case goes active and the respondent doesn't opt out. The first thing that the respondent will do will provide their response, provide their side of the story. And in that form that we have, it does include the ability to assert standard defenses, including fair use. So yes, fair use is definitely something that is part of our consideration, and it kind of comes up in those two main ways.
Okay, thanks. There are a lot of questions that we got around what kind of works. I just want to quickly answer that about, what about if illustrations, photographs are infringed? Definitely. The CCB hears claims on all copyrighted works if they're infringed. I'd like, there's a question about service, which I think is really opaque to non-lawyers. So can one of you just explain how service works?
Sure. So service is the process by which the documents involved in a claim are formally delivered to the respondent. So when we have a claim that's compliant, we will issue a notice of compliance and a service packet. And the service packet will be a PDF of everything you need to print out and to have sent to the respondent. That sounds simple, and I'm kind of like, the have sent to the respondent is the place that it can get tricky. So there are a number of ways that you can complete service. Some of us think of it like in the more traditional way of like hiring a process server and delivering it to the respondent. There are state laws that you can rely on. Some states allow service by mail. And so if your respondent is in a state that allows service by mail, you might be able to do that. But I guess when you're thinking about service, there's the who completes service, what's part of service, and when. And so for the who is, it can't be the claimant or anyone that's directly involved with the claimant. So we need a third party to complete service. So that's the who. And sometimes it can be a process server, it can be someone in the business of service, or it can be someone who is not in the business of service, but it just can't be a claimant. The second is the what, and as I mentioned, we give you the compliance packet. We will let you know, or the service packet, we will let you know exactly what needs to be given to the respondent. Nothing else, no more, no less, what we give you. And then the when is 90 days. You have 90 days to serve. And then the how, that's where it can be a little complicated, or it can be simple, depending on who the respondent is, whether it's an individual or a corporation, where the respondent lives, what type of state law is involved. We have a handbook chapter on service, and it's a good place to start. I wish I could say that it makes service seem easy, but it does at least provide some guidance about the way that you need to think about service. Terica, do you want to jump into to talk about any like resources that you're aware of?
And also the cost, Terica, if you could cover that. There have been a number of questions about like, what are the total costs of bringing a claim in the CCB? So in addition to the fee, there's the cost of service and any other costs.
Yeah, so as far as service itself, resources, the only ones I'm familiar with really are service processors. That's kind of what I probably expect a lot of people will end up using just for their expertise on how to execute service. And then for costs associated with filing a claim, I don't know exactly what the cost of hiring a service processor would be. I don't know if Whitney or someone else may know, but I can talk to the fees associated with bringing a claim before the CCB. So there is an overall fee of $100 that has to be paid in order to have a claim be heard by the CCB, but that fee is actually split into two tiers. So when you initially bring the claim, you have to pay a $40 fee. Once the claim is approved, you serve notice on the respondent. The respondent has 60 days to opt out. If they do not opt out within that 60 days, then you come back and pay the additional $60 second part of that fee for a total of $100.
Thank you. So another very, I think, an easy one to answer, and then I want to move on to sort of the bigger issue of, we've got a lot of questions about, well, if people can opt out, why is this going to be useful? And also, what if the respondent doesn't pay the judgment? Don't you then have to go to federal court to enforce it? So, but first, can you guys just talk a little bit about what do you need to provide to bring a claim? Like, what evidence? Do you need to provide copies of everything infringed, your materials infringed, and also the infringing materials?
So it depends. Eventually, we will want all of it before reaching a final determination. At the initial claim phase, what we need you to do is fill out the claim form. And that's, the narrative form identifying the who, the what, the where, the when, the why, and what relief you want. So you can complete the claim, and if we review the claim and it looks sufficient under the law and regulations, compliant under the law and regulations, we'll issue it forward. You don't need to include other documentation. Now, if you would like to include additional materials that you would rely on later in the active phase in the case, things like the copy of the work, a copy of where the infringement occurs, the registration certificate, any sort of communications back and forth between the parties that are not confidential, we accept those. There's a part of the claim form that allows uploading for supplementary materials. So if you would like the respondent to see that when you serve, then include it with your claim. Otherwise, that type of information, all of sort of the documents, the evidence that you're going to rely on to make your case, that's something that will be exchanged with the other parties during the active phase after the respondent has decided not to opt out. So you can provide, essentially, you can provide the information up front if you'd like. Otherwise, it'll be taken care of during the discovery process.
Thank you, Whitney. There was also just a question about can the CCB be used to make publishers pay royalties? That is an issue I hate to say we see way too often. And the short answer is that's not a copyright infringement claim as long as there's an existing contract. That's a contract breach. Now, if there is a way to, if you have the ability to terminate the contract, and if you're in that situation, come to the Authors Guild. Our legal services will help with that. And we can help you figure out if you can terminate. If you terminate, then, and they no longer have the license, and they continue to sell the book, then that's infringement, and you could bring a CCB claim. Someone asked me just to mention what kind of legal services the Authors Guild provides. We review all kinds of contracts, obviously publishing agreements, freelance agreements, speaking engagement agreements, option, film agreements. And then we provide copyright advice, fair use advice, defamation, all the kinds of media related, publishing related issues. And we do a lot of helping writers get paid. And also if you're having a dispute, with your publisher or your agent of any kind, we can help you out there. And there are other things too. We also provide websites for authors, that sort of thing. Next, I want to just, I want Terica, if you could just talk a little bit about, because this came up a lot during the lobbying for the CASE Act, like why, won't respondents just opt out? What's going to keep people, what's going to make this useful? And if you could also talk about how to get judgments enforced.
Okay, so just to kind of close the gap on something that I didn't mention in my portion. So if a respondent opts out, the case before the CCB is dismissed. So the case stops at that point before the CCB. And so, a question that I get a lot, just like right now in the chat, is, well, why would people participate if it's optional? If someone can just opt out, why would anyone participate? And I think one of the biggest reasons why someone might participate is, in particular, for people who have assessed the situation and realized that they do have some potential liability, like perhaps they did infringe a work and they didn't mean to, or they didn't, know that they were doing that at the time, but looking back, they realized that they did infringe someone's rights. And so meaning that they could potentially be opening themselves up to liability for having done so. When you look at the limited liability of the small claims process, the CCB, as compared to potential liability in federal court, I think there are going to be a lot of people who determine that it's not worth the risk to opt out and potentially have that claim brought against them in federal court if they were to take that risk. And when I say this, the next follow-up question that I usually get is, well, isn't it true that people can't afford to go to federal court? And of course, there are a lot of creators, a lot of copyright owners who cannot afford to file their claims in federal court. And that's a big part of the reason why the CCB exists and was created. But there are copyright owners who can afford to bring their cases to federal court. And in fact, there are some who bring their cases to federal court now, or have previously been bringing their cases to federal court, who now will opt to bring them to the CCB instead because of the cost savings associated with perhaps not having to hire an attorney or not having to, sit through a long, elongated process of federal court, may choose to go to the CCB instead. And so there's always going to be a risk if someone who has looked at the situation, assessed potential liability, and is just making a routine process of opting out of every case that's brought against them, there's definitely going to be some risk associated with that. And so if you're looking at $30,000 overall, compared to no limit overall in federal court, I think that's going to be a reason why some people would choose to go to the CCB. If you're looking at $15,000 damages in the CCB compared to $150,000 potential statutory damages at federal court, I think that's a reason why some people may choose to stay in the CCB. And then in addition, I want to mention insurance considerations. So particularly when claims are being brought against companies who have business insurance, and in a lot of cases, business insurance policies require businesses to notify the insurance of any kind of pending lawsuits. And so it may not be up to the business itself or the people who work for that business to make the decision as to whether or not they stay within the CCB or opt out. It may actually go to the insurance carrier to make that decision. In a lot of cases, they're looking at limiting potential liability, especially when they're looking at the situation and determining that there is some risk. So I just wanted to highlight that, and I can go into some other things, but for the sake of time, I think that's probably the biggest reason why people might choose not to opt out. And then Mary, you said there was something else you wanted me to touch on.
Yeah, so I think this is a really good question. Is what happens, you go through the process, you get a judgment from the CCB. You just can't get the respondent to pay up.
Mm-hmm.
How do you enforce that?
Yeah, so judgments before the CCB can be enforced by, going to the district court. And I know the most obvious question is, well, if you have to go to the district court to have the judgment enforced, doesn't that sort of defeat the process, or doesn't that get us back in the same situation? And I think the answer is no. It doesn't quite get you back into the same situation, because that's very different from having to litigate a copyright infringement case from start to finish. The amount of resources, the time, the money that goes into that versus simply having the judgment enforced in federal court.
And I'll also mention that enforcement is always a separate action. So you'll be doing the work anyway, whether it's in federal court or in the CCB. And I know that many people will tell you that, getting the judgment is only the first part of the process, and enforcement of the judgment can certainly be a separate amount of work. And there, it probably would be good to have some legal resources available as you move forward with enforcement.
Helpful. We're 4 minutes after the hour. Are you guys available to stay on for 5 more minutes? We haven't lost audience participants.
I can do 5 minutes. Yeah.
Okay, why don't we just do a few more minutes, just because there are a couple more really good questions that I want to get to. So, in federal court litigation, you get statutory damages if you have filed within 3 months or before the infringement. Is it different in the CCB? What happens? Because the publishers are supposed to, traditionally, published authors, their publisher is supposed to generally, it's in the contract, register within 3 months. They don't always. What happens if your publisher hasn't registered within 3 months and you need to register to apply to register to bring the claim? Is there a difference in the damages that you get like there is in federal court?
Yeah, so I'll touch on that, and if I miss anything or you want to fill in any gaps, Whitney, you can feel free to jump in. But unlike federal court, before the CCB, statutory damages can be awarded for works that are not, quote, timely registered. And by timely, I mean the time frame that Mary just mentioned. Those statutory damages are limited, so they're even more limited than the limited statutory damages for works that were registered within that time frame. So as I mentioned before, it's $15,000 per claim for statutory damages for infringement if the work is timely registered. For works that are not timely registered, it's $7,500 per claim, and the overall cap for those claims would be $15,000. So works that are timely registered, it's $15,000 per claim. The overall max for the whole case is $30,000. And then for works that are not timely registered, it's $7,500 per claim with an overall cap of $15,000 for those untimely registered claims.
Thanks. Good. And I want to just make sure everyone knows this is being recorded, and all attendees will receive a link to the recorded the recording. So one last question is, a number of people asked about this statute of limitations. How does that work with the CCB? How far back can you go? If someone started infringing you 10 years ago, but they're still infringing, can you bring a claim?
Yes, in short. Well, first off, I should say the asterisk is it depends on the jurisdiction. So with statute of limitations, we say in general that there's 3 years of a sort of a time period. And that 3 years is calculated one of two ways, either by the date of injury or the date of discovery. Most jurisdictions are going to be date of discovery. So we need to have a claim within 3 years of the date of discovering the infringement. If the infringement is ongoing, you can get relief for the infringement within the past 3 years. And then anything that's beyond that would be knocked out as sort of expired.
Okay, thank you. And as long as the infringement's continuing, you can, yeah, as you said, get damages going back 3 years. So, Johnny, can you please put up the resources slide? We do have a number of resources available to you, both the Copyright Alliance, the CCB have a lot of resources, and so does the Authors Guild. We have a page on the CCB. As I said, will be available to assist you, to assist members. I want to thank our panelists very much for participating. This was incredibly informative. So
thank you for having us
very much for your time. And with that, I guess we'll say goodbye. Please feel free to send follow-up questions. And as I said, we will be having a separate webinar on copyright issues. So stay tuned for that. Good afternoon, everyone.
Thank you.
Thanks, Whitney. Thanks, Tarka.